on Tuesday, January 30th, 2024 at 10 a.m. in room 131. I think that we have a quorum, so we'll go ahead and call the roll.
Senator Adams, Senator Douglas, Senator Harper Angel, Senator Higdon, Senator Howell,
Here.
Senator Mays Bledsoe, Senator McDaniel, Senator Nemus,
Present.
Senator Thayer, Senator Thomas, Chairman Schickel.
Present. The first thing I want to do is happily welcome back Amanda Mays Bledsoe to the committee. She is here, and we're so happy to see her after being absent for a while. Welcome back, Amanda. It's good to have you here. I believe we have some members that want to make some introductions.
Yes, Mr. Chairman, appreciate it. Appreciate you letting me have my intern for the session, Landon Crider, up here with us today. So appreciate you making him welcome. And I look forward to seeing Senator Mays Bledsoe's horse regulation bill of some sort that'll be coming through. Now that
You're out of order.
now that you're back, we can have fun with you.
We want to go over the rules again for the session just very briefly so there's no misunderstanding about how the committee will be run during the session as things get hectic. These rules get more important, but probably the most important one is we have a 24-hour rule on committee subs. I regret there's a committee sub today, as a matter of fact, and I'm going to try to figure out a way to get these subs online so that everyone can see them. Right now, only the committee members can see them, although we did, when I found out some of the interest groups had questions about the sub, I did instruct staff to get the subs out to the public just as quick as we could. Senator West, have a seat there. Welcome to the L&O committee. And then the way that works, if we decide to hear a sub and the 24-hour rule has not been followed, any member can object. If any members object, then the sub will be deferred. But I'd like to stay away from that since we meet on Tuesdays. I like to get everybody all their information on Friday so they have plenty of time to go over and look at it. I also want to apologize for canceling, and then rescheduling this meeting. If that caused any confusion, I apologize to the members for that. I know how valuable your time is. And with that, we will get on to the agenda. First, we are going to take the second item on the agenda, Senate Bill 50. It's great to have Senator Steve West in front of this committee. I believe it's the first time you've ever had a bill in front of this committee. And welcome, and introduce yourself and your guests for the record and proceed with your testimony.
Thank you, Senator. Appreciate the opportunity to present Senate Bill 50. I have a special guest here, if they would introduce themselves for the record. Go ahead.
Good morning. I'm Jack Mazarak with the Kentucky Distillers Association.
And Chris Nolan with the Kentucky Distillers Association.
And if you wouldn't mind, Mr. Chairman, I also have a special guest. I'm going to ask him to pull a chair up here beside the table.
That would be fine. Senator Special Guest, come forward.
There's one up here.
This is Peter Pogue with Pogue Distilling, which is in my district, Mr. Chairman.
Welcome, Peter. Have a seat. It's good to see everyone.
You have before you Senate Bill 50. I'm going to just give some brief background and let these guys take off. But I first arrived in the Senate in 2015, and at that time, we had a liquor bill presented, and we heard that this is the last liquor bill we're going to hear for a while. We're not going to have any more liquor bills, not going to have any more beer bills or wine bills. This is it. This is the last one we're having. I've been here 8 years. Every year that I've been here, we've passed or considered a liquor bill, a beer bill, or a wine bill of some sort. And to me, it's altogether proper that we do so, because what we're talking about is the rules of the road for the liquor business, how they operate. They're in the three-tier system, and we're tweaking the three-tier system, and that's what we've been doing since the 30s, basically. This bill is a simple bill. brought to me by the Distillers Association. It attempts just to give parity to micro distillers, similar provisions that we've passed for the wine industry and for the beer industry, for microbreweries. And it just increases the gallons that a local small distiller can sell outside the wholesale system. These gentlemen have gotten feedback and buy-in from the wholesalers, so we know of no one against the bill per se. They've done a lot of due diligence in the interim to bring all the parties together. I'm going to let them present, and then I'm going to let my constituent give a brief presentation of what Pogue Distilling has done and been able to do, just a brief couple-minute history, and please proceed.
Before you proceed, I want to point out to the members and to the public that this bill has been vetted during the interim, like all our bills are, so we're familiar with it. Welcome, Chris, and introduce yourself for the record. Proceed.
Thank you, Mr. Chairman. Again, Chris Nolan with the Kentucky Distillers Association. And I believe this is a first that the gentleman from Bourbon is sponsoring a bourbon bill on behalf of the industry. So we very much appreciate that and appreciate you, Mr. Chairman, and members of the committee. We always want to take a moment and say thank you to all the policy work that this committee and the General Assembly has done to modernize Kentucky's Prohibition-era regulation and tax laws over the last 10 years, and referencing the number of bills that we have passed. It's been a challenging policy debate at times, but please know that the Kentucky Distillers Association and our members applaud you all for the leadership that you all have provided our industry in setting important policy for the distilling industry in Kentucky. Without your all's help, we would not be where we are today, and we wanted to say thank you. So with that, I think Jack's going to kind of give a little short background of limited self-distribution and the need for it.
Jack Mazarak, Kentucky Distillers Association, and I couldn't agree more, Chris. We're here this morning because of those policies and how they've allowed Kentucky to attract craft distilleries and for those distilleries to flourish here in Kentucky, really across the state. For a decade now, these startups have added options and energy to bourbon's popularity, creating new jobs and tourism all across the Commonwealth. Many people don't realize that there were only 6 distilling companies in Kentucky 15 years ago. But today, there are more than 100 distilleries thriving in more than 40 counties. Of those, 60 plus are classified as craft distilleries. Those distilleries that are craft produce fewer than 50,000 gallons of distilled spirits per year. One of the biggest challenges a craft distiller faces is getting their new products onto retail shelves. Under the 3-tier system, a wine and spirits wholesaler is tasked with distributing and marketing a distiller's products to retailers. That can be a daunting task for a startup distillery with lesser-known products, whether it's aged bourbon or whiskeys, or non-aged clear spirits like vodka and gin. Kentucky's craft distillers are seeking the ability to self-distribute a limited amount of their product, allowing them to personally market and deliver to retailers and restaurants around Kentucky. Craft beer and small farm wineries have this same privilege. They were granted that several years ago to beer, and then last year to wine by the General Assembly and the work of your members of the committee. With Senate Bill 50, craft distillers would be able to garner new retail relationships and build their sales volume, increase their brand recognition, and hopefully then hand off those sales relationships to their wholesaler when volume is sufficient and they're a more noticeable brand. In this way, SB 50 would benefit all 3 tiers and bourbon enthusiasts.
Thank you, Jack. As was mentioned by Senator West a little bit earlier, we're very pleased to report that we worked throughout the interim and negotiated with our alcohol partners along the 3 tiers on this legislation, and we've reached a unanimous consent on this piece of legislation, which I don't know if that's a first, But we particularly want to thank Charles George with the Wine and Spirits Wholesalers of Kentucky and his members for sitting down with us and working out an agreement on the legislation that sits before you. It was a good dialogue, a lot of give and take, and both of our organizations are now supporting this legislation. Very quickly, some of the highlights. Craft distillers would be allowed to distribute up to 5,000 gallons of distilled spirits annually. The craft distillers can only self-distribute the product that is sold under their brand named or bottled or exclusively licensed to the distillery. We can only distribute products to retailers in Kentucky. That includes restaurants, liquor stores, and bars. And there are requirements that we worked on to notify, our craft distillers will notify the wholesalers when deliveries are made. Lastly, the distillery is responsible for paying all the applicable taxes and reporting what is self-distributed to the Alcohol Beverage Control on an annual basis. So that's kind of the summary of the bill, and we're happy to answer some questions. And Senator, if you wanted to add anything, or
I'll add one item. I'm sorry, thank you. I'll add one item and then hand it over to Peter for just a minute. Tell his success story and why this is so important. So, bourbon, the market has not reached saturation. All the studies that I know of show we're at least 10 years into the future before we even begin to see that. And so this is simply a way, with all the record tourism, with all the record investment, with all the people coming to Kentucky, this is a way for our smaller distilleries to sell more product and become more successful. And so I'm proud to present Peter Pogue, which is a family distillery that was there prior to Prohibition, and they have started anew after Prohibition. If you could chime in.
Welcome, Peter.
Thank you, Senator Schickel, and thank you, members of the committee. My name is Peter Pogue with the Old Pogue Distillery in Maysville, Kentucky, in Senator West District. And my great-great-grandfather started the H.E. Pogue Distillery in 1876. My great-grandfather ran it. My grandfather ran it through about midway through Prohibition. We had one of the 3 certificates to bottle during Prohibition, not distill, but to bottle. And what we're seeing now is the rejuvenation of craft distillers across the state of Kentucky. What our distillery is doing, both regionally and locally, is having an impact on tourism as well. And the tourism in our county and our area has blossomed over the last 3 years and will only increase with the opportunity to self-distribute. We used to self-distribute on the Ohio River, and now I think we'll do it up around the area regionally. I appreciate the opportunity to be here in consideration of this legislation. I would be remiss if I also did not acknowledge Tom Bard from the Bard Distillery and Autumn Nethery from Jephthah Creed. So we have representatives from across the state and all craft distillers. But thank you for the opportunity this morning.
Thank you all. This is kind of a happy moment, I think. I didn't realize, I mean, I knew the industry had exploded, but go, from 11 to, how many did you say, 11 to 106?
From 6 distilling companies with about 8 distilleries 15 years ago now to over 100 registered distillers.
And I remember well 15 years ago with Senate Bill 11 when we cobbled that thing together and worked our asses off to get it passed, and almost didn't. I remember charging down the House to get it filed, after the deadline, and I was so frustrated I was ready to quit, and Senator Thayer wisely advised me to keep at it, and we did, and I had no idea how successful it was going to be. And you talk about these craft distillers, and one of the things that to me is the biggest accomplishment has been the urban core and how the urban core has been affected. I have to give the craft brewers credit for that too, but the distillers and the brewers, we talk about urban renewal and government programs and all the things, money we've poured to try to revitalize the urban core, and I can't think of anything that has revitalized the urban core around the state than this industry and these industries, and it's all been private money, private sweat, entrepreneurs, private investment, and it's just really been a joy for me to be a small part of it. And I also appreciate the way this legislation was worked, where it was done in a collaborative effort where we didn't have to get in the middle of a big food fight in this committee. So we appreciate that. And I believe Senator Thayer would like to be recognized.
Thank you, Mr. Chairman. Senator, thanks for bringing this excellent bill, and I want to commend all parties who have negotiated on this, including Charles, who I'm usually castigating in these committee meetings, and today I'm not. I'm glad we were able to get that done before I leave, Charles, so you could say at least once I was nice to you in committee. Senator West is right. I mean, every year we say we're not going to have any more liquor bills, and then we find something else that needs to be done. And the reason is, after the American people had the good sense to repeal prohibition back in the 30s, state legislatures across the country, including ours, passed a lot of bills at the state level to regulate alcohol. And we've been steadily undoing a lot of those bills because, as I like to often say, we are removing artificial barriers to free enterprise, and this is another one of those. So well done. It's great to see Peter Pogue here. Our caucus toured the Old Pogue Distillery several years ago when we were in your district, Senator West, and it's a real jewel on the craft trail, real special place. In addition to the fact that the Old Pogue High Rye bourbon recipe is excellent, one of my favorites. So glad you brought your constituent here today. The chairman and I are on a small list of people who have voted yes on every bourbon bill to come before this General Assembly in the last 10 or so years, and I don't intend for that to change. So if a motion is in order, Mr. Chairman, I will make it. Thank you. I will move that Senate Bill 50 be reported favorably. Motion same shall pass.
Let the record reflect there's been a motion. Do I hear a second? Motion, let the record reflect Vice Chairman Nemes has seconded that. Any further discussion, questions? Is there anyone on the committee or in the audience wishes to speak against this bill? Madam Secretary, call the roll.
Senator Adams, Senator Douglas,
Aye.
Senator Harper Angel,
Explain my vote, Mr. Chairman.
Vote and explain.
I vote aye, and I want to be added to that list of legislators who have never voted against a bill that you've brought before me with bourbon and craft beer involved. And thank you.
Senator Higdon, Senator Howe,
Aye.
Senator Mays Bledsoe, Senator McDaniel,
Aye.
Senator Nemes,
Aye.
Senator Thayer,
Aye.
Senator Thomas,
Vote and explain.
Yes, like Senator Harper Angel and like Senator Thayer, and like yourself, Mr. Chair, I too, since I came here in 2014, have always voted in favor of bourbon bills, and I was honored last summer to receive an award from the bourbon as bourbon industry for being one of the supporters of bourbon over the course of my tenure.
Chairman Schickel.
I vote aye. Let the record reflect Senate Bill 50 is passed with favorable expression that same should pass. Congratulations.
Thank you, committee. Thank you, Mr. Chairman, for your hard work on this.
And I too want to thank Charles George, who's over there on the right. And Charles, I'm nice to you every committee meeting, but I'm gonna continue to be nice to you. And thank you for your participation in these negotiations. Okay, I think we have a room full of people for this next one. Next bill, Senate Bill 14, sponsored by Senator Reginald Thomas, and I'm the primary co-sponsor. Senator Thomas and I have been working on this for about 9 months, and we think we have a good product here for you. Is the cosmetology people here? Where?
Over here to the door.
There you are. Okay. We'll get you up here next. You by yourself? Okay, good. Good. Senate Bill 14, an act relating to beauty services. There is a committee sub for this, and I'll entertain a motion to adopt the committee sub.
Motion to adopt committee sub. Second.
There is a motion and a second to adopt the committee sub. All those in favor use voting sign of aye. All those opposed, like sign. Let the record reflect the committee sub is adopted. Senator, welcome. Introduce your guests and proceed with your testimony.
Thank you, Mr. Chair. I am here today to talk about Senate Bill 14. And I do want to say something before I introduce my guests. You had mentioned the committee sub. I want to say thanks to you, this committee sub has really been out in the public for now 10 days. So
I'm glad to hear that. I was hoping that I like them to get out. Yeah.
Well, I want to say that this has been out in the public, and the public has had a chance for the last 10 days to vet and review this bill. So this is no surprise. Everybody knows what we're talking about here today. As for my guests, I want to begin on my right and introduce Ms. Molita South, who's been involved in this bill since the very beginning. On my left, Ms. Leanna Wynn is here as well, and she's been highly involved. And then to my far right, Mr. Michael Carter, who's also been present from the very beginning. I believe brevity is best, so I'm not going to spend
Yeah, I think it is too. And so, I didn't mean to interrupt you, but just so we know the framework of what we're getting into here, we're going to allocate about 15 minutes for this testimony total, and then after that, we'll see if we need more. I didn't mean to interrupt you, but I think it's always good to people know what they're dealing with. But go ahead.
No, I probably will be about 5 minutes, and then I'll reserve the bulk of my time to respond or refute any comments made by the Board of Cosmetology. So I'm only going to be about 5 minutes. What Senate Bill 14 is designed to do is to both strengthen and support the nail tech industry. And the bill does several things, and so I'm going to go through it in order. I want to first turn your attention to page 2 at the bottom. What the Cosmetology Board has, which is highly unusual here, is the ability to bring criminal action against its members, bypassing the Commonwealth Attorney or bypassing the Attorney General and just filing criminal actions against people. And what we saw in Eastern Kentucky a couple of years ago was a really abuse of this authority. And there's been reports in the news articles about this abuse. And so we've taken that out. I just want to note that there are only 4 boards that have this authority: the Cosmetology Board, Diabetes Educators, Applied Behavior Analysts, Autism and Physical Therapists. Not even the Kentucky Bar Association or the KMA Association, Kentucky Medical Association, allow those boards to bring direct criminal actions against its members. So it has stricken that provision, and that's a big step forward. If you turn to page 3, there was testimony here back in June about conduct where the Board of Cosmetology would come in and just shut down salons, engage in, again, those type of conduct and tactics. Well, on page 3, we take that out. We say that if you shut a salon down, you can only do it for public health, welfare, and safety reasons. And of course, that makes a lot of sense. But even if you do that on an emergency, you still have to give them a hearing pursuant to Chapter 13B. You just can't just close them down. They have to have due process. And so the bill provides for that, and also says, look, let's not go to the death penalty first. Let's do this gradually, and if there's a problem, then let's give them notice, and then perform graduated penalties, which is what we generally think of as just the right thing to do. On page 4, we changed the composition of the board from 5 members to 7 members. We keep an odd number because, as we know, that's the best way to run any organization or board, is to have an uneven number so you can get a majority. But we put a nail technician on the board. Again, we give them a voice. This is a major industry in this state. Make no mistake about it. And you'll hear more about that. Okay, so we increased the board from 5 to 7 and required that a nail technician be on the board. Okay. Then on page 5, okay, what we've done is say that, there was an issue about test taking. So what we've done, and I do say we because I've worked closely with Chairman Schickel on this, is we say, okay, we're going to allow anyone who wants to be a nail technician to be able to take the test not once, not twice, but 5 times. We're going to give them 5 times to take the test to pass it. And they can wait a month and take it again, and wait another month and take it again. That's what we do in this bill, okay? And that really summarizes the bill. We've like any legislation, there have been some accommodations. There's been some compromises made, but that's the way this process is set up. It's set up so that, as my colleague Senator Thayer says, and I love to quote him, you can't forsake the good for the pursuit of the perfect.
Let me jot that down.
And this is a big step forward for the nail tech industry. So having said that, as I said, Mr. Chair, I was going to be brief. That summarizes the bill, and I'm asking for this committee's support for the bill.
You're right. You were brief. You only took 9 minutes. The ladies, are you? Would you like to testify? I don't know what could be added to that, but
Well, we're going to save the remainder of our time to refute or rebut any comments made by the Board of Cosmetology.
well, that'd be fine. Okay. I just want to, if the board, if you'll come up here and our friends from the Board of Cosmetology. And while they're working their way to the table, I want to go over the committee sub because the senator's correct. I did work with the bill sponsor on this sub, and a couple of things that we took out I think are important that the committee knows. There was a requirement for secondary language. We took that out. There was a requirement for unlimited test taking ability. We took that out. And what else did we take out? I believe those were the 2 major things that we took out. Yeah. Welcome. Good morning to you. Introduce yourself for the record and proceed with your testimony.
Thank you, Mr. Chairman. Julie Campbell, Executive Director of the Kentucky Board of Cosmetology.
Christopher Hunt, I'm General Counsel for the board.
I would like to mention, sir, this sub was not provided to the agency until this morning.
And you are correct, and I personally want to apologize to you for that. That is my fault, and I take responsibility for it. I mistakenly thought that it was up online, and it was not. As soon as I heard that, I told them to get it to you, and I apologize. It only did, and I will not make that mistake again.
Well, we did review that a bit this morning, and while it does make some adjustments to some of the board's issues in the bill, there are a few things that are still of concern. The board makeup, we have an entire licensing base that is being excluded if a nail technician is added, but not an esthetician. They have almost equal numbers to nail techs, and if a nail tech seat is going to be created as opposed to a second citizen member position, I feel it would be appropriate for an esthetician, which is one of the recommendations the board made in October to Senator Thomas. The other concern that we have, or one of the other concerns that I will be addressing, and then I'll turn it over to my general counsel, is that it states only nail exams in the last line about examinations being given within 1 month. Again, that is extremely exclusionary to the other licensing exams that we give for cosmetologists, estheticians, and shampoo stylists. So both of those.
Explain that to me again.
So we regulate and oversee 4 different primary license types with a variety of also practice permits. Those license types are cosmetologists, which make up 78% of our licensing base, nail technicians, which make up 15%, and estheticians that make up another 10%. We, at this time, though we have the authority and the education is out there, we have not issued a shampoo stylist license. But again, it follows in a restricted manner of a cosmetologist hair side of things. It just allows them to work on a blow-dry styling bar as opposed to a full service practice. So to exclude them from having a seat at the board when we're going to expand the board to a 7-member, I think is is an injustice to that licensing base. My counsel will speak to the legalities and the other issues brought up.
I want to thank everybody. Appreciate the opportunity to address the committee sub. If I may, I'll just go in the order that Senator Thomas did. The changes that are on page 2, which removes the ability of the board to bring some actions. I want to point out a couple of things. The board, to my knowledge, and certainly since I've been general counsel, has never considered that it had the ability to institute criminal proceedings, and it has never attempted to do so. The board has always read these statutes to mean that it could refer those matters to law enforcement and request that they assist and proceed. And indeed, sometimes the board has referred those and nothing has been done. And then we've had a couple and all of these have been in relation to unlicensed practice. So we're talking about a salon that's operating that's never been licensed. They've never attempted to obtain a license, or they may not have a personal license either. So that's the only time that's ever been done. The one instance that Senator Thomas referenced that was in the eastern part of the state, there were fraud charges related to that. And again, it was the same process. The board conducted its own investigation, pursued what it could do under an administrative regulation, and it referred that matter to prosecutors, to law enforcement, and they were the ones that initiated that process and made that decision. The board has never considered that it has that ability to make those sort of judgments. The other problem, if this is done, is there are provisions in there that if the board finds unlicensed activity, normally its jurisdiction, if you will, and its authority extends to license holders. And so if you have an instance where someone has no license at all, most of the normal enforcement mechanisms are not available to the board. You can't punish a license if it doesn't exist, essentially. And so these provisions were placed to allow the board to, again, refer it either to law enforcement or to institute a civil proceeding, ask a circuit court judge basically to issue an injunction against that person, and then attempt to enforce the injunction if they should continue to practice unlicensed. That's what all of this has ever been. So again, the board has never charged someone with a crime, to my knowledge. The other part is on page 3, and this involves in the case where one of our inspectors would come and maybe find violations, and so there's language in there at the bottom of page 3 of the committee sub that references an amount of time to correct a particular problem, and it mentions an agreement on that time frame between the board inspector and the salon owner. The problem is issuing those sorts of agreements or making those kind of decisions is not within the purview of our inspectors. It's the board's authority. It's not the inspector's authority. So our inspectors simply are not equipped or trained or authorized, frankly, to engage in that sort of negotiation. The second part would be if there's a lack of agreement on that, and I don't know how often that would happen. Obviously, this hasn't been done. But if none of the members of the committee have any experience with the 13B process, swift is not the word that anybody would attach to that process. So if we had a disagreement over a couple of days or something about that, if a 13B hearing process had to be spun up, that could take a lot of time to resolve. Then you end up with a lot of logistical problems. How do you proceed? What happens in the interim while these things happen, and so forth. So I think we would find a lot of logistical problems if that happened. We had also previously provided some information to the committee members that hopefully everyone has. I just quickly want to point out when it comes to a couple other things that Senator Thomas said very briefly. The board has, in very limited instances, used its authority for an emergency closure. And every single time, the board has followed a process which is in place now, which involves 13B. Every person who has ever been on the wrong end, if you will, of an emergency order has the right and the ability to appeal that on an emergency basis. We've had at least one person who has done that. We've conducted those hearings. There has never, ever been a circumstance where the board has entered a salon, found violations, shut that salon down, and afforded no due process whatsoever. There are no examples. They can't be cited. The process has always been followed. A person can request an emergency hearing in the event of an emergency closure, and that hearing has to be granted within 10 days. So it's not like it sits around for months on end. And that process is already on the books. Last thing I want to point out is if you look in the packet, the data sheet that we provided you is over the past 3 years, the board has conducted approximately 7,200 inspections. Out of that, 0.3% has resulted in some sort of closure on a temporary basis and so forth. And then of that 0.3%, it comes out to 22 cases. 12 of those, the salon owner, the issues were resolved and the salon was allowed to reopen. So if you go down to 10 cases in the past 3 years out of 7,200 inspections, you're at 0.1%. So it simply is not true that the board is out here running wild and closing people down arbitrarily and denying them their due process rights. The facts just don't back it up. But I appreciate your time.
And I appreciate your testimony. Do we have any questions from the committee? Senator Howe.
Thank you, Mr. Chairman. I've got a couple in no particular order. Going back to what you're talking about with the rather slow process of the administrative procedure, I've had some experience with that. In that situation, would that, by forcing this into the, I like taking this, I talked to Senator Thomas about that. I like taking this into the administrative process. And I hadn't thought this part through. Is the person affected, whether it's a whole salon or just one or two people, are they prevented from practicing and working while this goes through the administrative process?
They are
not
not.
in another facility.
What's that?
If the facility has been closed on an emergency order, their personal licenses are not revoked or restricted at that time, and they are able to take those to other locations or still use those professional licenses
But
in
the facility,
most incidents.
I'm sorry, I cut you off. But the facility owner would be stopped until that worked out.
Correct.
So would that hurt our? I don't want to do anything that the unintended consequences part, and I may be off on this, but would that hurt some of the owners while they're waiting to work through the administrative process?
So just to clarify. If an inspector, if the board finds that there are violations at a salon and they don't close them down on an emergency basis, and that person appeals the board's decision, that doesn't affect them. Then they remain open while the appeal is pending.
Good.
And they're not forced to pay anything or anything like that. The only way that they would is obviously if you got on the other end and the board's decision was upheld and the process had played out and ended, meaning they had exhausted all of their administrative avenues and so forth. In the event of an emergency order, they would remain closed, but they do have the ability to request an emergency hearing on that closure, and that has to be granted within 10 days.
Okay.
And that's built into 13B as well. Those provisions are there, and our statutes simply say that if the board takes that action, they do it pursuant to KRS Chapter 13B and all this process. So all of the standard of proof, that sort of thing, is all governed by that chapter, not ours. I hope that answers your question.
Thank you, Mr. Chairman. I have a couple others, if I can.
Yeah, go ahead.
I know there's no hard and fast rule on anything, but if someone, you had mentioned something about there's no impact, there's no consequence. If you can't take someone's license away from them for a violation that isn't licensed, in that situation where there's no license in place, do you treat that as kind of a present danger to trigger an immediate action? Is that kind of the way that works?
Absolutely.
Okay. And then you were discussing the instance over in East Kentucky that Senator Thomas referenced. By taking this process into the Administrative Procedure Act, nothing would prevent, because that's a crime outside of anything with licensing, nothing would prevent the board for taking that, a theft or something like that, through the criminal process. Do you read this? I know you hadn't had a time to pour through it, and I don't want to put you on the spot on that, but I skimmed this, and I didn't see where that would preclude the board from taking a theft action to a prosecutor outside of the Administrative Procedure Act. And I'm going to put Senator Thomas on the spot here in a minute and ask him the same question. But I don't think that would exclude this. But I could be wrong. What are your thoughts on that?
Well, I guess that's where the lawyers would get involved, I think, if we had a specific case. I think if these provisions are removed, I suppose one could view the board at that point as just as no different than a citizen who believes that a crime has been committed and may report it. The board's a little different. They have the ability in the administrative capacity to investigate. And so in some of those instances, we will have already conducted an investigation before we ever get to the point to know that we actually have unlicensed activity, et cetera, et cetera. I hope that's answering your question, but in this instance, I don't know at this point if this sub passes as written, that the board would have the ability, for example, to go into circuit court and file an action to seek an injunction, for instance, a civil remedy for this as opposed to a criminal one.
Which is there to protect the licensees who've worked hard and spent their valuable time and money to become licensed and are, proceeding as such.
And we would also end up in a situation if the board doesn't have these sorts of avenues, some process, if they encountered somebody, which they have in the past, who is unlicensed and has been contacted and told you need to have a license, you're in violation, and they just flout the law. Basically, they essentially say, I'm going to ignore you, and what are you going to do about it? Obviously, if they're unlicensed, we can't take their license, we can't put a fine against them, we can't do any of those things. So it looks here like you would have the high probability of an instance where you would have somebody operating a salon, and they have no incentive, there's nothing that would stop them. The board wouldn't be able to do anything other than to say, you're unlicensed, please stop, and that would be the end of it.
And just to be clear, I'm not aware of anything in the Administrative Procedure Act that allows for the type of immediate injunction that you're talking about with circuit court.
No,
am I correct on that?
That's correct.
Thank you, Mr. Chairman.
Anything else?
Not for me.
I believe that's all I have on the points in front of us. Thank you.
As you stated before, some of your concerns have been corrected by the committee sub, 2 or 3 of them.
Correct.
And I'm trying to follow the counselor's objections to it. But let's get the other side back up here for their response. Oh, I'm sorry. Dr. Douglas.
Thank you, Mr. Chair. Just one question.
Go ahead. Yeah, we got time.
Ms. Campbell, you all have talked about appeal time for hearings, or at least a time they can file for an appeal, and that appeal has to be heard within 10 days. Has that occurred, and have there been any incidents where it has taken an inordinate amount of time to get that appeal heard?
You want to answer that?
Sure.
We better situated to answer all those details.
So since I've been here, we've had 2 emergency orders that have been entered that the licensee has asked for a hearing. One of those went to a hearing, which we had, and that case, actually after the hearing, we ended up, the board and the licensee ended up having a discussion, and that's one of the ones that reopened. We had a conversation and we reached an agreement that enabled them to reopen. The other one reopened pretty quickly because, again, we reached an agreement before we had the hearing, but they had requested the hearing, and in that interim, everything had been sorted out. Now, there's some that we have entered where the licensee has never requested a hearing. They've never responded at all, frankly, to anything that we sent.
Or never responded to the emergency itself as a request.
Mr. Chairman, if I may.
You may.
I think that's all good information. My question was, and I'll repeat it, Has there ever been a time that it has taken more than the 10 days to receive the hearing?
And I apologize if I misunderstood your question. The short answer is yes, but that was at the agreement of all parties.
Thank
So
you
it
very
wasn't
much.
over the objection of a licensee, I mean.
Thank you, Mr. Chair.
You're welcome. Senator, do you wish to respond?
Yes, we will resume the tape.
Yeah, and I come on over and sit down with your guests. I would encourage you, especially your guests. We heard testimony from them during the interim. We want to keep the testimony to the facts and not and try to stay away from the emotions.
Well, one thing I know about you, Mr. Chair, you have no hesitation to cut people off. So we will abide by your request.
Yeah, thank you.
Okay. I want to go back to Senator Howe's question first about the ability of the Board of Cosmetology to bring civil and criminal actions against us. You and I are both members of the bar. Okay. The Kentucky Bar Association today. Let's assume one of our bar colleagues was caught stealing clients' money. Okay. The KBA cannot go into court in Fayette County or Callaway County and bring a criminal action against that attorney who's stealing client funds. Now they can pursue administrative action and ultimately decide they want to disbar that attorney. That they can do administratively, but they can't go into criminal court and say we're going to file a criminal action against you. The Board of Cosmetology currently has that right, and again, I respectfully disagree with them. They have abused that, and there's people in the audience today. They can't testify to that, but that's happened. Mr. Chair, I'm going to ask first Mr. Carter to refute some of the comments that were made.
I don't think we heard from Mr. Carter during the interim.
Yeah. You heard from him quite a bit. He was here during the interim quite a bit.
I stand corrected.
Good morning. Thank you for the time. In regards to the administrative hearings, 13B, the cases that were spoken about earlier in Eastern Kentucky, it's been 2 years since this school was closed down. The instructors, as well as the cosmetology license, were revoked. They requested a administrative hearing, and to this day, we have none. We had an individual in Louisville that his salon was closed down on an emergency order, not by the board, but by a phone call from the inspector to his supervisor. That hearing that was requested and had been postponed several times. It had been, I believe, 7 to 8 months. His business was closed. So the detriment to that business, it was ruined. There was no recovering from that in a service industry. The criminal process, these are violations, they're not crimes. So we had the KBC and inspector present to a grand jury testimony in order to get search warrants and proceed with criminal cases, including felony charges against licensed cosmetologists. And the prosecutor stated in the newspaper, as well as on the news, the cases were dismissed at a later time and expunged from these individuals' records because they found no evidence that was testified in the grand jury by the inspector. So when we say that the inspectors don't have the ability to negotiate, we're giving them the ability to stand in front of a grand jury and charge somebody with a felony or any kind of crime. That's wrong. These are violations. This is hair and nails. We have problems in the industry. We should be working with the board.
We got you.
Thank you.
Leanna, you have to be very brief. We're going up on an hour here, and I want to take a recess for a minute to consult with some people. So please be brief.
With talking about the nail industry in Kentucky, previously they would state that basically nail is a small portion within the cosmetology. I believe that's untrue. If you go to every area in Kentucky, every strip mall, shopping center, there's a nail salon, at least in one of that. Even in a dying mall, there's still a nail salon that's doing good in the dying mall.
Okay.
So that's what I believe in.
Thank you. Yes, ma'am. Again, very brief.
So I strongly disagree on the 10-day and response window because interviewer that have contact me to help out reaching out to the board. 10-day response, even though most of the nail tech or nail salon owner responds to the violation, but there's even in after 10 days there's no instruction on how to get the business open back up. Only when you hire legal intervention to talk to the board, or they won't talk to you for months. So left all the nail salon shut down without knowing where to go for the next route. Thank you.
You're welcome. I'm going to take a 5-minute recess. The committee will stand at ease. Thank you all for your indulgence. We will come back to order. As I said before, I don't like meetings to go over an hour, and I do, as chairman, have some questions about this sub after hearing all the testimony. I think we have a good sub, but I do think there may be a few small tweaks that need to be made to it, and I don't like passing things out and then fixing them on the floor. I just don't think that's a good idea. So I've talked to everyone involved. We're going to defer this to next week, pass over to next week, and I fully anticipate being able to vote on it next week. Thank you all. Is there anything else to come before the committee? Without objection, we stand adjourned.